Hello, this is Matt on the Moon Lambo channel. Folks, I'm going to stay out of the trenches here. There's been all sorts of name calling back and forth between Charles Gasparino, Fox Business journalist, and the XRP community. Now, most of the time, over the last couple of years or so, that Charles Gasparino has been covering what's been happening in the SEC v. Ripple case, I noticed that the vast majority of the time, it wasn't Gasparino that would typically, make the first punch. If somebody would insult him, he will always punch back if he catches it. But lately, that doesn't seem to be the case. Lately, it seems to be the case that if you have an intellectual argument, I've just noticed that there are some people that he's still just hitting back at and making claims about them living in their mother's basement and stuff. I'm not getting in the trenches. I refuse. But I am going to cover this because this is an XRP-centric YouTube channel. It's a crypto channel, broadly speaking. Of course, cover general finance, but it is XRP-centric here. So, of course, I'm going to cover this. But I got to call it like I see it here. And I've been a fan of Charles Gasparino even before, he jumped in and started covering the SEC v. Ripple case. But this, it's regrettable seeing that he is, punching back against people that are doing nothing more than offering open, honest critiques. And not only that, his article here from the New York Post, you would think that it was written by a Bitcoin maximalist who either A, wanted to deceive people, or B, was just uninformed. And I'm not saying that to be mean towards Charles Gasparino. I'm just saying that this article is factually incorrect and shows that he just does not understand the intricacies of securities laws. And not that I'm an attorney, but I've been paying great attention to what's been happening in this case for 2.5 years. And I'm going to cite what happened here. What he covered in this latest article on New York Post the other day. He titled it "Crazy Crypto Ruling Judge Shaking Up the $1.2 Trillion Market." And then attorney James Murphy, who is well-respected, incredibly intelligent guy, well-respected in the world of crypto, he just offered critique as to why Charles Gasparino was incorrect, and Charles Gasparino was making cracks about him living in his mother's basement. I don't think he even knew who he was talking to. He's talking to an intelligent, reputable, highly respected attorney who happens to comment on just broadly speaking, on things crypto-related. It's just unfortunate to see this. I don't find this to be necessary. I'd like to have intellectual back and forth here, but either way, I'm just telling you this, and I'm not saying this to be mean to him, but he is wrong about this, and I just got to call out the truth. But before breaking this down further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so to kick this off, there's just a couple parts I want to share with you from this article. I encourage you to read the whole thing if you have time. You can even pause as I scroll down if you want to read the whole thing just from this video, but there are just a few select parts that I want to highlight here. In particular, this, I think I'm going to start here. He writes, "Another gem from the judiciary came about 2 weeks ago, courtesy of a Manhattan federal judge named Annalisa Torres. Securities law experts say that she, in essence, ruled that small investors don't deserve the same type of protections as some dude working at a hedge fund. Yeah, you read that right. Judge Torres, of course, didn't say those exact words, but you don't need to be a legal scholar to decipher the upshot on her weird decision that's roiling the $1.2 trillion crypto market." Now, folks, you'll see as we go through this, the fundamental piece of the most crucial piece of knowledge that he's missing that renders this whole article completely useless and inaccurate is that he's not differentiating between an asset and a scheme. So just like in the Howey case from SCOTUS back in 1946, it's not the oranges or the orange grows themselves that are securities, it's the totality of the package and the way in which they were sold. It's not the case that because W.J. Howey Co. was found to have sold unregistered securities that those oranges, once they're sold on secondary markets and grocery sales, it's not the case that those oranges suddenly are also illegal securities because of that. Forever and inextricably linked. No, that's not the case. Of course not. He's missing a key piece, but he's still writing this with authority and confidence in the New York Post, but it just isn't true. It literally, absolutely, unquestionably isn't true. And so go down here, and I just want to get to the meat of that part of the argument. And I think it was, I think this is the part right here that I wanted to cover. I think this is it. Torres's ruling, meanwhile, makes some of the most absurd legal arguments impacting securities laws and now crypto regulation. Some of Ripple's XRP sales to those Wall Street fat cats were in fact securities and demand disclosure because these were so-called investment contracts, she declares. Then she rules that Ripple's disclosure-free sales to small investors were totally kosher. So pause right here. Ripple never sold a single XRP to small investors, not once ever. Not once ever. That's literally not true. And so just think about the same thing compared to Howey. In the Howey case, those are illegal transactions, people agreeing to have property maintained. There's orange groves and oranges are getting sold, and they're hoping to get a profit from all of that. Okay, so that was illegal, right? But then, if that orange is sold to somebody, and then it's sold to another person and another person, it doesn't matter how many people he keeps selling the orange to, it doesn't mean that they're tied to that investment contract with W.J. Howey Co. They don't even know W.J. Howey Co. exists. It's the same thing. So he wrote something here that literally isn't true. And then he does talk about how they're blind in the next sentence here. So then why say that they sold to small investors, which isn't true, when after that you contradict it? So he says, according to her logic, or he wrote their illogic, because they purchased their XRP through an intermediary, like an exchange, they were not entering into investment contracts. So folks, again, he's calling that illogic. So if you want to be logically consistent, compare it again to the W.J. Howey case, 1946. Is it the case that you go to a grocery store and buy an orange, that you're also in an investment contract? Or is it some sort of slimy way out? Oh, no, they know. Of course that's part of the W.J. Howey Co. They bought that orange at the grocery store, and that came from W.J. Howey Co. Are you kidding me? It's a blind sale. They have no idea about that. And so he says here, though, quote, these blind sales aren't securities, so it's perfectly legal for Ripple to stiff the little guy on disclosure. Folks, I don't even think he understands how crypto works if he's saying that. Because by the nature of fungible tokens that are decentralized, you can't control who does what with it. Once it's out of your control, it goes to the next person. They can send it to or sell it to whoever they want. And that's stiffing the little guy? That's an incoherent concept. I'm sorry, Charles Gasparino's just wrong on this stuff. I'm not attacking him. I'm challenging his ideas. His ideas are absolutely wrong. And then he says, in her words, both sides won, both lost. And now one really knows how to proceed going forward. What may have escaped Torres and her law clerks is that the vast majority of regular stock purchases on apps or from your broker are similarly blind. Yet Apple, like all public companies, provides lots of disclosures because the law says small investors need them more than hedge funds. And so there you go. You're saying that you could purchase Apple stock blind, but that's still a security, right? So that's the same as if you buy XRP blind. That should be a security too. That's the argument he's making, but that's wrong too. And I pulled this up before, but you can Google it yourself. Google Securities or Exchange Act definition, and this is what pops up. This is on a ton of different websites. I pulled up the data from Cornell, but this is the definition, the actual definition of security. I don't need to read the whole thing, but here you can see it states in part, the term security means any stock, any note, stock, treasury stock, security, feature, so on and so on and so forth. Nowhere in there is cryptocurrency. Nowhere in there is digital asset. Nowhere in there is XRP. It's not the same thing. A stock, by the nature of it existing, constitutes that agreement, that concept. It is, by law, by definition. But oranges are not included in there either. XRP's not included in there. He's missing this crucial concept. And so if he really talked to securities lawyers and he was persuaded by them to this degree, I wonder to what degree those attorneys are credible, because they are citing a bunch of bogus bunk nonsense BS. That is absolutely what has happened here. But so again, he's fallen for this argument. I don't know if he thought of it himself or if he got it from one of these attorneys that just wants to sway him in an incorrect way, or it's an idiot attorney. I don't know. But yeah, if you sell, wherever you buy Apple stock, it's still a security no matter what. It's literally in the definition. But oranges aren't in there, and neither are cryptocurrencies. Neither are beavers. Neither are chinchillas. Neither is whiskey. And those have all been parts of schemes which have been found to be illegal securities transactions. It doesn't make the asset itself that a security. He's missing such a crucial concept that we've been discussing for years here within this community. For years we've known this. I don't know how he's been covering this, and he's missing that fundamental concept, which blows his argument to smithereens. It just does. And so here you have Attorney James Murphy, who goes by the name Meta Lawman, and so he highlighted this article from Charles Gasparino, and he shared the following. And you'll see that it's definitely a critique, just like I'm critiquing Charles Gasparino, but I'm not personally attacking Charles Gasparino. I wouldn't do that. I'm not going to ever do that. And Attorney James Murphy here is not personally attacking him, but he is criticizing, and I'm criticizing because that's what we should be able to do. We need to be able to challenge one another's ideas respectfully, right? And so here's what Attorney Murphy says. This Charles Gasparino column is a great example of why I oppose censorship. I believe everyone should be able to read Gasparino's ill-informed and nonsensical column attacking Judge Annalisa Torres' decision in the Ripple case. Gasparino calls the Harvard-educated Judge Torres acutely witless, and he describes her decision as absurd, weird, bizarre, madness, and dangerous. Gasparino cites anonymous securities law experts for the idea that Judge Torres, quote, ruled that small investors don't deserve the same type of protections as some dude working at a hedge fund, end quote. This is, of course, false. If billionaire, he wrote Charlie Fink here, he meant Larry Fink here, and he acknowledged that in a separate tweet. But so he wrote, I'll just correct it. If billionaire Larry Fink of BlackRock buys XRP on the secondary market, it's still not a securities transaction. This is readily apparent from the decision. So think about this. So he's saying you're protecting the big guys, the institutional purchasers. They're protected, but the little guys not. But again, as he points out here, very succinctly, if Larry Fink, CEO of the world's largest asset manager, BlackRock, if they purchase XRP from secondary markets, not from Ripple, it's the same situation. It's still not a securities transaction. There still are no specific requirements or disclosures from Ripple because they didn't buy from Ripple. So it's not just the quote-unquote little guy that would be in that situation. It is also institutional sales. And this also gets back to this idea of it's not the underlying asset that is or isn't the security here. It's the scheme. It's the totality of the circumstances. Gasparino doesn't get this fundamental aspect, and he wrote an entire article lacking this crucial piece of knowledge. So we got to push back against this because it's an incorrect idea. It's the right thing to do. And hopefully he would just acknowledge this at some point and then issue a correction, because that's what one should do when you are to this degree incorrect, because this is misleading people. And then Charles Gasparino says, Gasparino then attacks Judge Torres' law clerks, arguing that they don't understand how stocks work. But it's Gasparino who misses the critical distinction between stock and crypto tokens. You do not acquire equity in a company when you buy a token. Unlike stock, crypto tokens do not carry with them any rights against the issuing company or project. That's why a token like XRP is not a security. So I'll pause and note again, that's why I was sharing with you this information from Cornell Law School. And this is one of many sites that has published this. The term security, what it means, the definition of security. Stock, treasury stock, security futures, so on and so forth. It's on your screen again right there. That is different. Stocks, if you're purchasing equities, there are certain legal requirements that come along with that. Not with oranges, not with cryptocurrencies, though. And so, again, that's why Attorney Murphy says that's why a token like XRP is not a security. You don't get any special rights by purchasing it. And then he says judges don't get to clap back when they are subjected to baseless attacks by politicians or columnists like Charles Gasparino. It is the responsibility of lawyers and the American Bar Association to respond forcefully when defamations are launched against the judiciary. There you go. And so you can see Attorney Murphy didn't hold back in critiquing the content of what Charles Gasparino wrote, but he didn't engage in a personal attack, did he? Nor have I. And I'm not going to, ever. I refuse to. Yet Charles Gasparino saw that thread from Attorney James Murphy, and he retweeted it, and he engaged in a personal attack rather than engaging in thoughtful intellectual discourse. This is regrettable. Charles Gasparino retweeted that, and he wrote, quote, "It's great that some dude living in his mom's basement and calling himself Meta Lawman has found a new hero in the great Judge Torres. Probably another one of her rulings he supports can be found here, and then he leads to another, links to another. I don't want to get into other rulings. It's not the purpose of this, but I'm showing that it is the case that Charles Gasparino, unfortunately, he's punching first. If you critique him now, he's going to punch first, because critiquing, I guess he perceives that as a personal attack. That is, as adults, that is not how we should perceive things. We need to recognize that we should be critiqued. And that's why if he or you listening, anybody wants to critique my ideas, unless you're actually including an attack against me or being rude in the critique, which I can spot, that's one thing. But if you're just challenging my ideas, I welcome that. I think debate's fun. I enjoy that. Plus, if I'm wrong and you can show me that I'm wrong, then I would like that. I'd appreciate it. That way I can stop being wrong, because you know what? Sometimes I am wrong. Just like you're wrong. We're all wrong sometimes. And I don't want to believe things that aren't true. And I don't want to pretend like I'm always right. I don't like know-it-alls. I don't like people who can't admit when they're wrong. And neither do you. Who likes a know-it-all? Who likes people that can't admit when they're wrong? You can't trust them then, can you? Because they're if you're talking to somebody that's not going to admit when they're wrong, you're talking to somebody that you just can't trust. You can't, because you won't know when they know that they're wrong, but they're still trying to convince you of something. That I don't want to live like that. I don't want to be perceived as that. So what do? If I get something wrong, I'm just going to say it. So I don't know. We'll see what happens here. He seems to be very firm on this position, and anytime anyone, and I've seen there have been a handful of people here that have been putting forth pretty reasonable critiques here, he just doesn't respond to any. He responds to everybody that insults him, and he insults them back, but he doesn't respond with thoughtful discourse to people who are critiquing his ideas in a respectful and thoughtful manner. That is unfortunate. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo!